The NASCAR Antitrust Trial is underway in Charlotte, and as expected, it has had the tensions and contention in the courtroom where Peter Stratta was, and Johanna Cox, our legal expert, was looking on. And of course, she is from Stiletto Group in New Mexico. We will get to them just a little bit for some analysis. First, kind of just going through the first couple days. The first day, opening arguments, and then we had Denny Hamlin taking to the stand, giving his testimony. Moving into the second day, where we saw Hamlin take the stand again. Cross-examination happened, and then we saw Scott Prime giving testimony, executive, and a lot happening, a lot going on, and the mood in there seemed tense. Peter Stratta would be able to tell us even better. Peter, when you were in there, just kind of give us a perspective of what it was like in there and what you saw.
Yes, thanks for having me on, Jonathan. First and foremost, it was very low temperatures, very high tensions, like you said a little bit ago. A lot of conflicting opinions from both sides, obviously, two very impassioned arguments, and both attorneys did exemplary jobs of presenting their cases to the jury that we will spend the next 2 weeks, obviously, learning a treasure trove worth of information about through hundreds of pieces of evidence and documents and all that glory that is sure to be coming in the next couple days coming down the pike.
Definitely. And just want to start with the opening arguments because, we sort of heard from 2311 and from Road Motorsports, their side talking about, this is kind of like being a nurse in a town that only has one hospital. And if you want to work in that profession, you have to go with that hospital no matter how the conditions are. And then NASCAR kind of giving a different rebuttal and side in their opening statements. So what did you gather from both sides?
I think both attorneys did a great job of being upfront. I believe Kessler said there were four pillars of the team's argument, and then John Stevenson, NASCAR's attorney, not Chris Yates yesterday, it was John Stevenson speaking yesterday. He said there were three pieces that NASCAR's trying to prove through evidence, and they both did a great job of laying that out throughout their hour plus allotted time with a lot of detailed information. Obviously, evidence wasn't allowed yet in opening statements, but they both say a lot of evidence is coming to back up their claims and refute the opposition's claims.
And just kind of looking at it, what were some sort of like key like takeaways or things that kind of, when you heard it was like, huh, that's interesting, or like that could really stand out.
I think a big standout moment that stuck with me yesterday was when Kessler mentioned that NASCAR has been paying SMI to not hold events at their properties, to not have any potential of any competing event. And their justification was that was part of a clause to maintain integrity and maintain that their premier level racetracks to hold the biggest events possible. And that in reality, so many racetracks around the country, whether it's Charlotte, Bristol, Texas, all these SMI properties are actively not holding events, but being still paid very handsomely.
It's interesting, of course, because as we've seen, the judge, of course, ruling NASCAR is a monopoly. This trial coming down to, did NASCAR become a monopoly, maintain that monopoly through anti-competitive acts? So with that said, kind of want to bring in Johanna Cox here, of course, Stiletto Group in New Mexico. Yeah, I know you were following along pretty closely. Kind of give your perspective of what you saw through these opening arguments and how it's going to relate to the rest of the case.
Well, as an attorney who's done several trials in several different venues, the opening arguments from the legal perspective were pretty predictable. Good overview of what they're going to present, what they anticipate to show. I know there were, at least since I have to watch through the eye of Twitter or X, whatever it's going by now, I basically, it looked like there were some sort of disputes or at least some feathers ruffled about the use of visuals during opening arguments. That was the only thing that kind of stuck out to me. Usually those get resolved either by the attorneys or through pretrial orders with the judge, but it sounds like they were still kind of duking it out or trying to get some things visually presented to the jury in opening statements that were not necessarily something already approved. And I don't know, Peter, maybe you can help clarify some of that. But otherwise, it seemed pretty predictable. We talked a little bit, Jonathan, the last time we spoke. This is going to be a complicated case. It's set for 2 weeks of trial. The attention span of most people is about 30 minutes. So that's a lot of information over many, many days that the lawyers are going to have to get out. And the KISS principle will probably be really key in how this gets presented. So whichever one the jury understands the most or the best is probably going to be where they end up falling later.
Yeah, Peter, go ahead.
Yeah, just touching on what you said about the dispute about showing evidence in the opening statements, that was an issue raised by, I believe, Kessler and his team yesterday, and the judge would not allow it. So we just proceed with opening statements that were purely spoken. Each attorney just gave their case to the jury from merely just presenting it to them, the nine jurors, just no different than I'm talking to you now.
And NASCAR also sent out a message to the media after the first day. Some of the things they brought up were none of the allegedly anti-competitive conduct raised in the lawsuit in court today were raised during the negotiations, laid out how many meetings there were, etc. How the teams asked for the charter system, negotiated with NASCAR, brought up that, and also questioned 2311 of why did they buy a charter not once, not twice, not three times? Why did Front Row Motorsports do what they did? If the system was unfair, anti-competitive, and below market. But as we started to get into the testimony from Denny Hamlin, there were a lot of really telling things that, yes, we are making money, we are doing different things, but it's there's kind of an asterisk to it, as you heard, Peter.
Absolutely. Denny was upfront and said 2311 Racing has been profitable every year up until 2024. And he mentioned that a large chunk of why they were so profitable was being so closely aligned with Michael Jordan, that's a big strategic advantage for them in garnering sponsorship, which, as you, myself, anyone knows, is more and more expensive these days. So any sponsor who's on the fence, if they get a phone call or a meet and greet with Michael Jordan, they're obviously more likely to say yes to 2311 Racing or their drivers. So Denny made the point that just being so closely aligned with MJ, having his hands on the wheel of 2311 Racing is a big factor in why they've been profitable all but one season.
Definitely. Yeah. And when you look at that, you think about some of the numbers that have remained, pretty much sealed up until this case and the trial and everything. Were there any things that kind of stuck out to you as Hamlin was testifying that were like, whoa, this is eye-opening or insightful, or that, we didn't know before?
I wouldn't say I didn't per se know this number before, but both Hamlin and Kessler reiterated multiple times that for an average Cup Series team, it's $20 million just to field a competitive car for 38 weeks. That's just crewing the car, building it, maintaining it in the shop, and getting it to the racetrack. That's not factoring into that number, driver salary, any other operating cost. That's simply building the car and getting it to the racetrack. So that number seems to be a big sticking point in this whole case. One of the pillars of their argument is the teams want a $20 million payment per year per car from the sanctioning body. And I think that's just one of the biggest numbers we've heard so far and will continue to hear in this case.
Definitely. And kind of going over some other numbers I know were mentioned. Of course, Hamlin mentioned $8 million he pays per year for support from Joe Gibbs Racing. Talked about also the factor of sponsorship and how it's a make or break thing. Talked about Germain Racing. I thought that was interesting. One of the 11 original 19 charter teams that have gone out of business since, that who originally signed on to the charter agreement. Johanna, kind of, throwing it back to you, when you hear about testimony like that, I mean, talking about businesses, the different teams that have gone out of business, talking about the numbers and whatnot, how does that kind of lay the groundwork for everything that is to come in the next few days?
So I think it gives some reference points for starting. If you've ever owned a business or you've ever, tried to start a business, even sometimes you are not necessarily profitable. So if the comparison is simply these teams did not make it and they were part of the original charter, that doesn't tell me quite the whole story. Was it something that, the way they ran their business, were there other factors, maybe the driver got injured, or I mean, there could have been a lot of different reasons that they didn't make it that weren't necessarily related to the charter. I did, in all of the online reading that I do with the trial, I did read somewhere that Front Row Sports hadn't had a profit for 20 years, but they've still managed to exist for 20 years. So I think there's just, as far as context goes, I wouldn't wrap up the whole analysis just whether or not a team or a group is profitable, but let's look at other parts of their business. I mean, they do spend money in other ways, they do other things. They've bought other charters, so they're not going bankrupt and totally defunct. And the ones that did, maybe look at some of the other details. But remember, all of these have to still be relevant to the part of the antitrust lawsuit that is going forward. Yes, there is a monopoly, but it was defined very narrowly as the stock car racing in the United States. I'm an attorney. There's millions of attorneys in the country, but if I do just my neighborhood block, I am a monopoly here because I'm the only one. So even though that's been defined, we still have to look and see whether or not these were anti-competitive things that NASCAR put into place that caused it to these sorts of things to happen. That hasn't come out yet. We're still on day 2. I mean, I think we got through maybe 1.5 witnesses with it. I mean, I don't know if they finished all of the direct. Peter would know that, but it sounds like he's going to continue to tomorrow. So maybe 1.5 witnesses. So there's still a long way to go to really give these numbers and this context a little bit more substance for the jury.
You said it perfectly. We've gone through 1.5 out of a possible 36 witnesses. So definitely buckle up, grab your popcorn, because this movie will be a while. It may make something like Avengers Endgame feel like a pretty short movie by the time it's all said and done.
For sure. You talking, we're obviously talking very personally here about different things, kind of lighthearted, sort of, you know, lightening up and whatnot. That kind of happened when Hamlin got on the stand. His attorney, of course, Jeffrey Kessler, asked him about, hey, how did your season end? How did you get into racing? Kind of hitting those different points. I kind of want to get analysis from you, Peter, on what you saw, and Johanna, how that tactic kind of works. But first, I'll start with you, Peter.
Yeah, of course. Denny seemed obviously really personable, really just relatable when he first got on the stand. A lot of his questions were just simple background. Where are you from? How long have you lived in the area? How does one become a NASCAR driver? How did he get his start in racing? That's when he got choked up mentioning his father, who is more than likely terminally ill. And ultimately, we all know the backstory with Hamlin, his career, his father, all that, but the 9 jurors don't. None of them are racing fans. None of them know who Denny Hamlin is. So this may all seem like basic information to us inside the NASCAR racing sphere, but in reality, this is brand new information to those 9 people who will ultimately decide this case.
And Johanna, like I mentioned, kind of setting the stage, if you will, kind of tell us about like your experience, I guess, in the courtroom with, doing this and kind of laying the groundwork for a case.
Sure. So Peter kind of described it very well. That's exactly what the lawyers were going for. They need to not only just personalize these random people that are sitting in front of the jurors because I mean, they have no idea who they are from Adam, but the background and the context just of NASCAR and what it means to be a driver I think is important. So it's a very common tactic. I think it was very helpful. My understanding is he did well. He did testify well. At least that's according to much on the Twitter line. That's kind of what they said. And he also, though, is paid really well. I mean, the jurors not only heard his story, and I am sorry about his dad. That's a terrible thing for anyone to go through, deal with, and then be put in a witness stand for sure. But he also does comment that he made, I think it was $14 million because he wins. So that it does give them a lot of different context on the driver's side of it. Since he is a professional athlete, it does help them understand that side as well. But I think it was a good start to not only just bring some personality, like a personal side of the personality to the courtroom, but also give the jurors an idea of the sport and kind of how it works in that context.
For sure. And we move into the second day. Of course, Hamlin's testimony continuing. Of course, this was the chance for NASCAR to cross-examine him. You mentioned the salary. One of the things that came up was, you make $14 million a year. He talked a lot about his different investments, how much money he owes Michael Jordan, for different loans and things like that. What did you guys kind of gather from the second day, from what you've seen and what you've heard and what happened?
My biggest takeaway was yes, Denny's paid very handsomely, and yes, he's one of the top two or three highest performing drivers in Cup today. He goes back to still that prime era of the sport. He came in right at the tail end of it. His rookie year was 2006, so he's used to driver contracts, driver salaries being up in that 10 teens millions range per year. But he also is a very not shrewd business person. I mean, he came out yesterday that Airspeed 2311's campus cost $35 million, and he was being pressed today on why spend so much to build your facility when you could just run it out of a simple building, a simple garage. And Hamlin went into details on that both yesterday and today. And that from that came the money that he still owes MJ, I believe, for helping construct and helping fund Airspeed.
And Johanna, what from what you kind of gathered, what did you see from today's proceedings?
I'm going to just piggyback on Peter's comment there for a minute. That specific facility, for instance, may not be available to all the teams. So although we had discussion and testimony about 35 or I'm sorry, Peter, if I got the number wrong, I think you said 35 million. But whatever that number is, that doesn't show that NASCAR was responsible or created an anti-competitive situation. That is him getting a really big loan. So even though these big numbers are getting thrown out, think, and I'm hoping the lawyers, this caliber of attorney should get through the next few days to kind of wave through numbers like that aren't really pertinent to this particular claim. It's not something that is available to all teams. At least to my knowledge, not all of the teams have these kinds of facilities or the ability to build these types of facilities, but that doesn't necessarily make it an anti-competitive basis. So that's kind of what I took away from the rest of Hamlin's stuff today that we haven't touched on.
Definitely. And some other key notes that were brought up as well by Hamlin. He mentioned that he had a conversation with NASCAR CEO Jim France. Jim France said, you guys are spending $20 million a car. Why not, spend 10 million for a car? And Hamlin kind of laid out why that wouldn't be possible, talked about a conversation he had with Jim France and said he felt very discouraged after the fact. Also talked about the profit margin, of course, for 2311 Racing. 2.36% was what he mentioned for the number, and said basically, I'm one sponsor away from having all the profit be gone. And a very telling testimony. Also on the cross-examination, we heard from NASCAR's lawyer talking about how much he wants in damages, and bringing that up, and bringing up kind of the number that has been thrown out there. Also been talking about just his positive comments for NASCAR, and also the different things he said on various different outlets. Of course, talked about Kenny Wallace's podcast. And Hamlin gave a pretty pointed response to that, didn't he, Peter?
He definitely did. He said he was somewhat using NASCAR's PR speak, their talking points to help promote the sport, and that if a driver doesn't do that, then they get a not so nice phone call or whatever correspondence, whatever communication from NASCAR leadership. So you could say he was somewhat not trying to bite the hand that feeds him per se, but that brings into question if he's willing to say anything on whatever other podcast, whether it's his own show, the Dale Jr. Download, Kenny Wallace's show, what have you. Can he fully be trusted on what he's saying on the stand?
And Johanna, when you kind of hear that about, being one sponsor away from, the profits being gone, when you hear about, speech kind of being limited, obviously I know this isn't a First Amendment case or anything like that, but, just in regard to antitrust, what do you make of that?
Well, on the profit piece of it, I'll try to address both of them one at a time. But on the profit piece of it, again, look at the business that's underlying it. And is the profit really then leading to the anti-competitive part? Is that really going to get the plaintiffs where they want to go by making those types of claims? That's going to be up to the jury with respect to the, statements he was giving the NASCAR spiel, like he's required to give the spiel. Any other driver, let's see what they say. And if it's all going to be consistent or things like that, then the jury should hear it over and over for the next 2 weeks. So, Peter, you're going to be the one that'll probably guide us most in that. But we'll see what the jurors actually get to hear at that point. And the use of all that other, his other statements and things like that, that's a basic impeachment type of evidence. So it was appropriately used, by the attorneys and everything. And it'll be up to the jurors who are the fact finders to see if any of that, gets the plaintiffs over that hump, that preponderance hump at that point when they ultimately make that decision.
And I think one thing that's interesting is that there are, you mentioned like drivers, speaking to that. Interesting to note on the witness list, there aren't any drivers on the witness list, at least from what I saw. There were some team owners, but yeah, no drivers on the witness list from what it looks like.
Yes, it's the owner or an executive from every major team in the Cup Series, a couple of representatives from the RTA and other uh, racing adjacent organizations, but no drivers. Denny's the only driver in that list of 36 potential witnesses. So, in terms of hearing what a driver has to say, I think we've heard everything we will hear.
So, Johanna, just to kind of get an idea from you, how do you handle something like that that isn't exactly apples to apples?
It isn't. Ultimately, the jurors will make that decision. But that was the selection of witnesses is up to the attorneys. And so there was a strategic reason that no other drivers were selected or put on the list. I know in some of the previous pleadings, there was some discussion and discovery about documents from the teams and different things like that. So if I was a plaintiff's attorney and those were helpful, I'd be trying to get those teams or those documents in. Obviously, from NASCAR's, if they were helpful for their position, the same thing. So we'll have to see ultimately then what actually gets admitted, because just because you have an exhibit list of, I think I saw a number of 140 different or something crazy like that, over 100 different labeled documents. That's not the number of pages, it's the different labeled documents. But you've got potentially hundreds of exhibits and almost 40 witnesses. Just because it's listed doesn't mean it gets admitted, and just because they're named doesn't always mean that they get called. So we will see how that goes, but it was a strategic decision. Apparently, both sides made that agreement.
One key thing I want to mention as well, it was brought up throughout at some point in the day that, the Franz family, they made $100 million in a particular year. And meanwhile, we heard the deposition from Bob Jenkins, the owner of Front Row Motorsports, that he had lost $100 million since he first began his team. So I'm just I want to get some analysis from both of you, from NASCAR perspective and also legal perspective on just kind of, your thoughts and what it looks like for this case as well.
So Kessler at one point yesterday made a point to hammer home NASCAR privatizing ISC, even though they had majority control over it. It's no longer a public company as of 2019. That means the France family directly has control over a majority of the racetracks that NASCAR competes at. And NASCAR's attorney rebutted that, saying this takeover was or went to the DOJ's antitrust division, was approved, and everything was following the law there in that takeover. So I think that's a big chunk of the France Family Trust making that large chunk of money in that time. And it may not look good on paper, knowing the financial status of many race teams, but it's trying to connect two dots with a pretty broad brushstroke.
I'd have to agree with Peter there. We're going back to, again, even just because the number's there or making a profit of something, looking at where it came from, the source funds, and what it's used for, I think is indicative. And it going through the DOJ investigation, specifically in that example, I think will be helpful for NASCAR. So we'll see. And depending on how the trial goes, the lovely thing about trials, they are like living things. So they will change from day to day, as you both are well aware. So what I say today, in 2 days, we could be having a whole different conversation because all this is excluded and something happened. But at least for today, that's probably where it'll go or how it'll go.
For sure. And of course, ended the day, the second day, with some testimony from Scott Prime, of course, a NASCAR executive, heads NASCAR strategy. One thing that I thought was interesting, kind of reading through the notes and everything from today, was about there used to be the 5-year deals in NASCAR with the tracks, with making sure that tracks will be able to host races for 5 years. Of course, they have since done away with that. It's more on a year-to-year basis, and it's more of a patchwork. But he talked about how like those multi-year deals have really helped the tracks and the companies, not be vulnerable to outside interests. And I thought that was interesting, considering what's at the root of this whole case with, the permanent charters and everything.
Absolutely. We saw obviously during that 5-year span for for a majority of it, the Cup Series schedule remained largely unchanged. I think for probably 10 plus years, the final four races were Martinsville, Texas, Phoenix, Homestead without budging. The playoff schedule remained largely the same. The whole regular season largely remained the same. And really, ever since having to reorganize the schedule because of the pandemic and that 5-year deal expiring, we've seen so much schedule change. But you bring up a great point with that leaving the tracks in a vulnerable position because just for 2026, look at the Watkins Glen race weekend. They're typically a late summer, early fall race weekend. Now they're being moved up to May, and there's no guarantee that fans that usually pack out that race weekend will return in such different weather conditions at a such different time of year while kids may still be in school.
And Johanna, I'll just kind of add on to, Prime talked about how the negotiations with NASCAR, it kind of seemed like NASCAR had the upper hand on the negotiations, kind of almost similar to what the teams have been talking about. So, I mean, I guess, when you look at this, what really is like the significance, with his testimony and what he said, and what you gathered from it?
So I think it's easy to say that NASCAR had the upper hand because they're the big governing body, if you will, in this racing situation. They're the officials and all of that kind of stuff. What we'll have to see, though, again, and I'm going to sound like a parrot, but ultimately, does that mean then they are still not a competitive type of entity? Are the drivers still able to compete? I know there's been discussions about there being other options for drivers. They did not have to get a charter. The charters themselves are a little different than, long-term or multi-year agreements with a track, which is a location. And I'd have to agree with Peter that, this vulnerability for the fans, for the drivers. I mean, I don't know if you've ever, done endurance type sports, but even like I'm a runner. I do, marathons and half marathons. Running, in the mountains here in New Mexico is very different in May than it is now in December and January. And so just your training style, for the drivers, for their crew, all of the stuff that goes into the vehicles themselves, it's going to, all be impacted in different ways. So we'll kind of see how that goes as far as that vulnerability. But ultimately, again, with the NASCAR and referring to them kind of as the big elephant in the room, if you will, it'll be up to the jury on whether that actually made them non-competitive or it just was a big brand.
Definitely. A couple more things to add before we kind of get to the what we think is going to happen next. Denny Hamlin, of course, was asked about the exclusivity clauses that he had built into it was Riley Herbst's contract. Reports indicated, NASCAR kind of asking him, well, you have exclusivity clauses. You're kind of pointing out exclusivity clauses that we bring up. Hamlin said, of course, we're not a monopoly. Judge had proven NASCAR was a monopoly coming into this. Obviously, that was a big component of this case. Looking ahead to the rest of the trial, Johanna, from what you've seen so far, obviously, I know we've gone through 1.5 witnesses and, very early on, but, what do you believe is the key takeaways or key things that you've seen so far that will play a big role in the rest of this trial and the cases that each side is trying to make?
I think what we've mainly got the last couple of days is just a foundation. You've got just maybe a little bit of the framework. I don't think that's quite come out very much. And maybe it's just because I'm an attorney and I kind of understand the little pieces that each witness brings out. So I'm looking at it differently. Peter, you can add some insight. But I do believe right now we just have the foundation. We need to give people, the jurors specifically, the context of how the teams and NASCAR interact, how they work, what goes into it, what does this mean? The exclusivity type of things got brought up. I did see that. And ironically, not all states will enforce those either. And so it's going to be interesting how things like that get argued, because if it's not an enforceable provision of the contract, if that's, the way it gets argued. And I do not practice in North Carolina, so substantively, I am not licensed there, just as a legal disclaimer. But if they have that same kind of framework as other jurisdictions, it may not matter if it's in the contract. So we'll have to kind of see how all of these play together. But I think we're very early on, very tip of the iceberg, but getting some good framework. I'm guessing we'll get a little bit more probably through tomorrow, maybe the morning of Thursday, and then get some really good meat and potato right before a weekend and going into next week.
And let me just build off of what Johanna said there, calling this the tip of the iceberg and a foundation. Being in the courtroom yesterday and seeing how the jurors reacted to this fire hoses worth of information, a lot of it was going over their heads. Obviously, they're not racing insiders like you or I, Jonathan. They're not racing fans. So ultimately, a lot of the next couple of days may be kind of a NASCAR 101, kind of teaching them the sport. And ultimately, this is a very complex sport, a very vocabulary heavy sport, and not just simply a stick and ball sport that is pretty easy to pick up on. There's a lot of little pieces, parts, intricacies, rules that may or may not have to be explained in depth to the 9 jurors.
Yeah. And one key part of this whole trial, of course, is the witnesses, like we talked about. Question for both of you, What witness or which witnesses are you looking forward to the most in this trial?
I would have to say Richard Childress because he has obviously recent spats with both sides of this case. So I'm not 100% sure whose side he would favor in this case because obviously messages from NASCAR executives have come out about him recently. Those won't be used in trial as evidence, but were still made public. And he's gone back and forth with Denny Hamlin and with 2311 Racing. Ultimately 2311 did take Tyler Reddick, the driver, away from RCR. So if he is called to the stand by either side, he may be throwing barbs out of both ends of his mouth, may throw a zinger or two both ways.
I think we'll probably get some zingers from a lot of witnesses. This is a very emotional and high stakes trial. The decision is going to have a reverberating impact in the sport in general, but potentially other sports we've talked about, Jonathan. So I'm going to sit here with my popcorn and wine and watch your tweets, Peter, and as much of everything else as I can. So it'll be a fun couple of weeks for me.
For sure. Yeah, I agree. I will be watching with my popcorn and well, maybe not wine because I'll kind of have my phone with me when I'm at work. But alas, we'll have some good tea or something like that. Yeah,
Okay,
it's
I'll
gonna be
say
interesting.
coffee then. I'll
Coffee.
say coffee now. But it'll be wine in the afternoons. Come Friday afternoon, Peter, I'll cheers you.
Absolutely. We may need something stronger than wine when we're all done with this.
You will. You will.
Well, as Judge Bell has said before, hey, if you guys want to burn down the house above everybody's heads, I will be there as a fire marshal come December, and we here we are. So it's going to be interesting. I think one thing that'll be interesting to see as well will be the economists. I know that's not the most sexy, if you will, part of the trial, but it's going to be interesting to see a lot of the numbers thrown around and kind of paint the picture of what we might see, and then be followed up with all the barbs and zingers and one-liners and everything they'll be to come. So it's going to be interesting to see. So, Peter, where can everybody find you at?
So I can be found on Twitter, just my name at Peter Stratta, and that's Stratta. My content can be found on YouTube as well when there is a film aspect to it. So those are my two main platforms, Twitter and YouTube.
TSJ Sports, there, yeah, Peter Stratta, Noah Lewis over there. Those guys do some good work. Of course, you can find them at the track. Johanna, where can people find you at?
I'm on Twitter also, Johanna Cox, and also I have a website, Stiletto Group, stiletto-group.com. And I am an economist, so I will look forward to those discussions. That will be a lot of fun.
Numbers, numbers, numbers. Money doesn't talk, it swears, as Bob Dylan once said. Well, my name is Jonathan Fjeld, from the Racing Experts. You can find me on Twitter, of course, on theracingexperts.com, and we will keep you posted on what all is to come. All of us in here. Thank you, guys. It's a lot of fun. We'll see you soon.